So the theme of this panel is data, hence the title, Data Panel. I am absolutely delighted to moderate this panel because all of the scholars that we have, including Robert and Christopher, that I will introduce in just a second, bring something which I would describe, and I hope this is not, you won't take that as being offending, but not purely legal. And here's why. When it comes to Oli sitting next to me, what I like in your work, so to introduce you, you are a professor of law at San Diego School of Law, and you bring the legal fields and an understanding of the ecosystem that surrounds those legal interpretations that I think is very impressive, and we can only hope that more people will engage in this kind of research. When it comes to you, Beatrice, so you are a professor of law at Sciences Po in Paris. What I like especially in your work is that, as you will discuss on this panel, I'm sure you, of course, are a lawyer, but you have a clear understanding of the governance dynamics. We've talked a bit about that today during the first two panels, and I hope that we can, deepen the expertise when it comes to, again, understanding what are the issues outside of the legal fields. And we are joined by Christopher Yeo from Penn University. Very nice to see you. Now, when it comes to your work, what I think is very clear is that, and I'm actually curious to hear from what you have to say on the subject, because you are at the law school, but you must have an economic background. I must admit that I have not checked that, but it clearly appears from your work. And so, again, this is a nice way of connecting what we've heard on the first two panels today with some issues related to data. And the last speaker on this panel is Robert Meharry from the MIT. So as you would expect from a scholar from the MIT, Robert brings technical knowledge, technical expertise. You are at this stage probably publishing in technical journals more than you are publishing in legal journals, but you do have a JD from Harvard Law School. And when it comes to the interconnection between what we can learn from the tech literature and bring that to the legal field, I think you are a very unique scholar. So, that being said, I will start the panel in just a second by giving you all 3 minutes. What I do have to disclose beforehand is that Christopher has to leave 15 minutes before the end of the panel, so you will hear the bonus question that I have for you, Christopher, before I will ask the questions to the other members of the panel. And then what we have decided is to divide this panel in two different sections. Part one, we will be trying to identify the issues related to data. And then what we will do is maybe not come up with all the solutions, but explore why the solutions that others, including policymakers, have identified already are actually not so easy, or maybe they may produce some perverse effects. So that's what I want to discuss. On that note, I did not do in alphabetical order. I do it in a more emergent way. So I'll start with you, Beatrice, who appears first on my list. So I give you, again, only 3 minutes to go through the main issues that you discuss in your contribution to the network law review. Yeah, could you maybe, yeah, thank you.
Sure. So thank you, Thibault, for that question and for the invitation. It's really great to be here. So my brief article is kind of an issue spotter exercise, which is a very lawyery thing to do, trying to identify what are the main claims over the data that is being used to train generative AI models. And I see there's mainly 4. So there's the copyright case, and this is training data, so not the outputs. So there is a copyright case where you have creators of different sorts, more or less upset because their text usually, but also their images, is being used to train generative AI models. One of the big cases out there right now is the New York Times lawsuit against OpenAI. Different stakeholders are reacting differently. Last week, Le Monde in France closed a partnership with OpenAI to let them use their data undisclosed for how much money. But like some of them are seeing this as direct threats, some of them aren't. A second big issue is a privacy argument or data protection. Using information that we all have available online for training generative AI models might be considered data processing. That has privacy and data protection implications. Some of the challenges there is that sometimes models can regurgitate is the word, which I find funny, but it is some of that personal data. And there's, in the European Union, there are ongoing investigations by the European Data Protection Board, but Italy has sort of been at the vanguard of pushing for that. A third one is data scrapping from social media companies and others. So one of the things that we've seen is that companies have been training their terms of service to say that scraping their, and that's when it starts getting tricky, the data that they host on their websites for AI training purposes goes against the usage. And so we saw Reddit change its terms of service, Zoom did something different. And the law there is kind of ambiguous. So for those of us who've been in the open data movement for a couple of years or close to that, we thought that that information online, we've been pushing for that to be considered kind of public. And now we see really a strong push from companies trying to keep it behind their digital walls, I guess. And the jury is kind of out. And in the piece, I go over the like pros and benefits or that. And then the last one is the scraping of what we actually consider commons. So Wikipedia is one of the main examples. Wikipedia is an important source of training data for generative AI. And there's maybe a policy question of whether that's okay. And that's kind of where my paper gets a little bit speculative, and then I'll finish with that. And is that those of us who've been advocating for open data for many years, we were saying this is important for competition, this is important for innovation, this is how the small people get to play. And then that was sort of working, but wasn't going far. And then it turns out we were right. So this capabilities to scrape the internet at large became enabled. You had all these databases that had been built for those purposes. But it turns out that the people who managed to profit from that aren't exactly the small entrepreneur activists had in mind. Those are also vast, large tech companies. And so I guess in my own work, in that piece, I'm kind of dealing with the policy questions of whether that's okay. So now there's 7 very big tech companies in the world instead of 5 or 6. But again, how do we sort of distribute power if that's what we want? And what's the role of data governance in that? That's kind of...
All right, so now if you haven't done so already, what I would recommend you do is that you take Beatrice's contribution and you put it next to Christopher's contribution. Because you have a different background, you tackle similar issues, copyright, privacy, governance, and it's not that you come to conclusions that are not compatible, but I think it gives a holistic view, which is exactly what we need, and hence the theme of this conference and the reason why we have such a nice conversation, I would say, since this morning. So we'll move to you now, Christopher, and give you 3 minutes to, again, give us a flavor of the core arguments that you make in the paper. We cannot hear you well for now. Yeah, I think.
That?
No, I don't think it's on your end, Chris.
Yeah, it's coming from us, so...
They're getting like it's really small.
Yes, now it works perfectly well.
All right, how about now?
Yes.
Great, thank you.
Fantastic. Well, thank you for inviting me. It's a delight to be a part of such a distinguished event. As you mentioned, about interdisciplinarity, it is a very important part of my work. I am not only appointed in law, I also hold appointments in computer science and in communication. And to me, it's very much the direction of what we do here at Penn. For example, 70% of our students graduate with a degree or certificate from another school. And it's very much in the DNA here. But to me also, it's emerging as a critical issue in these fields, particularly bridging over to computer science and data science. And what I think is that sort of the thrust of my paper can be taken as a critique of a very simplistic view of data. Many people reduce the idea that the fact that certain companies may have amassed a large amount of data must necessarily give them a tremendous competitive advantage. And it's in essence, it treats all data the same and assumes that volume is sort of has inexhaustible returns to scale. And very much reminiscent of some of the earlier literature on network effects, where everyone said, "Oh, there's network effects. There must be market failure." We now know that's just not true. That in fact there must be diminishing returns to scale, and that there are devices such as multi-homing which eliminate the winner-take-all aspects of this. And what I've seen there is that in fact there's an open question as far as data goes in terms of what its relevance as an input is. So for example, just on a pure scale advantage, we're having increasing indications that for certain business models, it's not as important as we think. I'll cite, for example, in search, the Google search trial is going on in the US. One of the standard claims apparently is that Google constructs its search results on a sample of 0.1% of its available data. So in fact, its revealed behaviors that it's not actually that necessary. And even the adverse witness to Google during that trial, when asked what market share it needed to have sufficient data to be able to generate queries, a former Google employee who'd set up a rival search engine said 2.5%. And a 2.5% scale is not generally what we associate with sort of tremendous advantages owned by proprietary actors. And in fact, we need to think critically about scale and in respect to, not in the abstract, but with respect to particular business models. I mean, bear in mind, we think about large tech companies, if they're doing search or e-commerce or social networking, the idea that the scale effects would be exactly the same in all of those domains would be coincidental beyond all expectation. And that in fact, it's not just what the size of the data, but in fact, the nature of the data that you have has tremendous impact. And in the different business models, how new it is and how old it is matters a great deal. Now, a lot of this, today we're talking about generative AI. To make the pivot from data in general to generative AI in particular, one of the issues that came up in the Google search trial is that, setting aside whether or not there was a scale advantage in data in the past on how we used to do search, Bing has now essentially shifted its entire the basis of its search engine to emphasize more and more generative AI. And unlike the traditional approaches to generating search results done by traditional search engines, which did build on prior search queries and the responses, generative AI is built on, as Beatrix said, large-scale public data. And so the notion, to the extent to which search becomes based on generative AI, the role that proprietary prior search data plays in developing search results is going to be dramatically different. In fact, it's going to be your ability to deploy LLMs, get that data trained up and the like, and that's going to be a very different dimension. And in fact, what we're discovering there in training generative AI, it's not just volume. There's other aspects about quality that matter a great deal in terms of determining the outcomes. So the big takeaway from, I hope you'll take from both the piece I submitted for the symposium and my remarks, is that we need analysis, not epithets, which is we can't just say, oh, there's a lot of data and therefore there must have these outcomes. That is clearly a possibility, but it can't just be assumed. We can't assume that more data is always going to create additional benefits, and we can't assume that it's going to have the same effect in every context. In other words, it's more a market-by-market traditional analysis that we normally see in competition law to understand how things go, as opposed to just saying, oh, there's a certain data threshold. Once you exceed it, there must be some policy problem that takes place.
All right, thanks a lot. Now, to quickly react, obviously, as volume meant being in a position to take the entire market, Apple wouldn't be striking a deal with Google now to integrate their AI because Apple has a lot of data. Something some of you may not have tried yet. I have no tie to this company, but that's Perplexity.ai. That's a search engine that is Gen AI based, and you would see it's quite different from the experience using Google and quite interesting. And now you've mentioned scale. So if only someone was to start, okay, I mentioned that already. A podcast on scale, that would be great. All right, I'll move on to you, Robert, now. because we've been talking about output data, but maybe there is more we may want to consider here. So the floor is yours.
Thank you so much. You can hear me all right?
Yes, it's perfect.
Perfect. Yeah, so I'll provide maybe just a couple of sentences of background about the piece and kind of how we came to be interested in the topic that we ended up covering. Sometime in the last, I think it was sometime last summer, we put together a group of mostly computer scientists and some lawyers who are interested in understanding the provenance of AI training data, specifically kind of fine-tuning data or curated data, that is to say, not pre-training data. And we called this the Data Provenance Initiative, and we ended up looking at almost 2,000 data sets that were represented some of the most kind of widely used data sets. And together with a fairly large team, we were able to analyze where did the data come from, who are the creators, where are the creators located, what languages are covered, what kind of tasks do the data sets focus on, and what are the license agreements that are associated with these data sets. And so we created a tool that computer scientists can use to kind of curate data sets in ways that are useful to them, whether that's around specific NLP, natural language processing requirements, or legal requirements. And so from this analysis, from this kind of landscape analysis, came this kind of interesting question, which was, here we have data sets that are different from pre-training data sets. So they're not just, scrapes of Wikipedia or something like that. They are actually data sets where someone has put a significant amount of time and effort into creating labels that are useful from an AI training perspective. And now they've put a license onto this data set. We find that oftentimes these licenses are reported incorrectly or kind of get lost in translation. But the question is like, well, to what degree are these licenses enforceable? And so we started looking at, how are people justifying the use of these curated data sets? And oftentimes you hear arguments around fair use. And so what the article that we submitted to the symposium tried to explore was the distinction between applying fair use to pre-training data sets, where the underlying data, say Wikipedia, was created for a purpose that is very, very different than training AI models. And comparing that to fine-tuning data sets or supervised data sets, curated data sets, there's a couple of words where the purpose is essentially the same, right? So someone spent all of this creative energy, created a data set, sometimes literally from whole cloth, like people write down, starting with nothing, a data set that would be useful in an AI training context. And then says, the reason why I've created this is to train AIs. I'm publishing this openly as an academic. And then, I'm putting a non-commercial license on. And so we essentially go through the fair use analysis briefly in the paper and come out that it seems like more of a stretch to apply fair use to curated data sets than to pre-training data sets. And this is especially interesting because these curated data sets are actually quite important from kind of if you're looking at the most recent generative AI breakthroughs. And then we kind of outline a couple of things that make things even more complicated, right? So like, of course, it's not as easy to say as, well, fair use does or doesn't apply. And I think one of the most interesting pieces that we see is that for a fairly significant chunk of the data sets, another large language model was actually used to kind of create some of the labels. And those large language models, especially OpenAI's, have terms of service that prohibit the use of their service to create a competing service. And so then you have these like interesting legal questions that are on the horizon. I'll leave it there, and I'm excited to kind of discuss more of this.
Yeah, more on that in just a second. But before I move to you, Oli, so what I truly appreciate in your paper is that you do something which I think is really rare, which is to make a point that at least I never considered, and you expose that in such an accessible way. Then once you've read it, you're like, of course that makes sense. Why didn't I think of that before? This is what you do in your paper. So please, enlighten whether they have considered those issues that you are talking about when it comes to watermark and so on and so forth.
Well, thank you. Thank you both, Oregon for lack of a better word, this is not on. For lack of a better word, this conference is generative, generative of ideas and exchanges and engagement. I am also just very honored to be here and spend the whole week at the Institute. So if you're still around, I think on Wednesday, on March 26th, I think there's a book talk that I'm doing. And in fact, I think about a lot of the issues that the first three speakers talked about, but I kind of pivot in this particular paper. So I think about ownership and copyright and fair use and innovation policy in general when it has to do with AI and our race toward these markets. Here I ask a very specific question, which is there a broad principle that people have a right to know about artificiality? So should there be a notification, or should users, citizens, consumers be, as a matter of default, informed that they are either interacting with a bot or that they are seeing an image that's generated by an AI, or they are reading something that has been generated by AI? And like Beatrice, this paper is very much a mapping exercise, but it's a mapping exercise to make the point that the answer is really context-specific and complicated, much more than the default yes that you see in a lot of these kind of like AI Bill of Rights or the new acts that we're seeing and the different initiatives. So I guess like Christopher, I'm kind of calling, and I think I've seen this throughout the day, that this conference is really people who want to be based on analysis and not epithets. And that's what I try to do also in the paper. I say, well, you know, there might be a need for, you know, whether it's, we call it transparency or notification or the right to be informed, and, you know, the whole spectrum of then, you know, explainability and appeal, all of these kind of regulatory toolbox that we see in AI. I have a different paper that just came out that's called the AI Regulatory Toolbox, and I kind of map those. But it depends what the purpose is to have that, and we really have to tether the solution to a problem if there is a problem. And that's something that, again, I think is also in the first three papers that were just presented. I think that's part of the issue, that, you know, when people say, oh, there's, you know, some infringement going on when when a bot is, an algorithm is trained on data sets. Not always is, for example, copyright really the right tool to tackle the problem that is being raised. For example, distributive justice, kind of winners and losers, and wealth creation. That, you know, it might be that copyright is just a kind of like everything is dumped on it. So that's a more that's a little bit of a side comment. But what I do in the paper is I say, first of all, we should separate between two different kinds of reasons of why we sometimes demand or policymakers think that there's a right to know about artificiality. One is more deontological or dignitarian, where there seems to be this idea that we humans are very much invested in the knowing of whether we're still in kind of the human natural zone of personhood. And it's just in and of itself really important to us to know that suddenly there's a shift. And that in itself, you know, I'm not questioning that might be important in some circumstances. Maybe to some people it's always important. But if that's the one reason, I very much argue that it can be in tension with other goals and benefits of artificiality or automation. I then go to the more kind of shifting from deontological to the utilitarian reasons of why sometimes we want to, you mentioned labeling, watermarking, generative AI as such, which are, again, I have a whole list, I think I have like these 7 reasons, and I won't go through all of them, but it might be that being notified of the source of the interaction, whether it's a chatbot or the generation, if it's an image or text or video, can give us, the viewers, the users, some kind of information about whether to trust it more, how to understand it, whether it's more or less likely to infringe upon our privacy, to protect the data that's collected, that we interact with it. And then another reason is really to know about ownership and attribution, and to kind of not have the liability risk of appropriation or infringement. So again, I can unpack each one of those more, but just to say there's lots of different reasons, and a lot of times if like you choose, I want to have a law that creates a right to be informed because reason number 4, then again, we have to be very science-based of whether information about artificiality actually achieves that goal. And I show from I'm a behavioral researcher, I show that sometimes that's exactly the counterproductive. Like if you want more safety and better human-machine interaction, sometimes like these pings about notification, like, hey, this is an automated system that's landing the plane, will actually be counterproductive. So I'll end here. Yeah.
Thanks a lot. So now what we're going to do is move on to part 1 of the discussion, in which we try to identify issues related to data, and I'm going to process in the order of the training from the creation of a foundation model to indeed the use of the model. So I start with you, Beatrice, actually. So you do argue that data governance should look at or facilitate open data, access to data, data sharing. Now, as we've already heard from Christopher, of course, if you have no data at all, you don't have a foundation model. But what you may also have in your data set is data that is unique. I give one example. It could be access to YouTube data. Why is that unique and important? Because it tells you, of course, if someone prompts the system, what are the top 5 videos on YouTube? If you don't have access to that, you cannot answer. But more fundamentally, this access to YouTube data will give you access to the transcript of all the videos and the comments, so you see how society is reacting to certain subject, which is very valuable information, right? So if you ask, what should I wear this winter in Berlin or this spring? Well, maybe the answer is actually in the transcript of those YouTube videos and comments. So here's my question. How far should we go in terms of spreading access to this unique data that, as you mentioned, Reddit, Stack Overflow, that companies want to keep private? We know we have the directive on copyright in digital single markets that kind of says, well, it has to be more or less open. France is challenging that, so it seems that there is a push to actually make it, stricter and more proprietary. So again, would you argue so that every data can be used for the purpose of pre-training a model? Would you argue that, well, it should be shared amongst certain companies, or that we should actually, give companies the right to just restrict access to this unique data?
Yeah, so I've thought about this question because you sent it to me in advance, and I still don't know. It's on, I think? No? Yes? Okay. Yeah, so I don't know. And I've thought about it because you asked me beforehand. But I can say a little bit about how I'm thinking about it, and then I guess it'll be a good conversation, I hope. So far, there's been no regulatory tool that really forces opening data from private companies that is like non-published, and I think the publishing part of it is important. So you have YouTube videos is a good example, because those are somewhere in the open on the internet. Like you can watch those videos actually without logging in, which is a difference, and you could, in theory, scrape them down with a lot of complicated computing that I don't quite understand, but that's like a possibility. I haven't seen ever not even the Data Act in Europe has forced, I'm not sure, has forced Uber to open up the data of all their rides so that the little guy can understand what are the hotspots in the cities for managing their algorithms and their services. So I think there is something of the interest of companies of keeping their market advantage based on the network and the economies that they have built. And so I think there's this, Robert mentioned fair use. I think there is something true to maybe the principle that you maybe should be able to use that data if you are not going to compete directly. And by saying that, I'm already closing the door and protecting the big guys, but I think there's something to that. Privacy, for example, I think is an issue that we should be somewhat flexible with, so long as it doesn't actually endanger individuals somehow, so that each person's data is kind of lost in the flood of information. And so I'm personally less worried about that. But then if that's somehow something that can be used afterwards or can repeat information about me, that's something that I would stress about. I worry most about the enclosure of information that we thought was open, and now given the rush to train data or secure your data, like further enclosure. I think there might be something that we are losing there. But I think those are very tricky policy questions. It depends on a case-by-case basis. What type of information are we talking about? If it's very sensitive, if it's not, how it was collected. And so it depends.
And putting a price, of course, would then lead to all the friend litigation. You know, it's quite interesting. Last week, the CTO of OpenAI was given an interview and was asked, did you train OpenAI using YouTube? And she did not answer the question. She said she didn't know. Now, people are saying she knows and couldn't say, or it's also possible that, I mean, allegedly she really doesn't know. So I move to you now, Christopher. So you do make a parallel between search and explore what we can learn from past antitrust cases in the US, and argue that, well, historical search data could play a role, but as you also said, big data is not the end game. So the question is, what could competition agencies monitor in the space when it comes, again, here to data? Is there, or should it be part of the agenda of what competition agencies should indeed track and try to scrape?
They need to the agencies need to keep up with what's going on at the cutting edge. And unfortunately, the discourse isn't really there right now. There's a real challenge, which is to do that, you have to hire data scientists, and that labor market's extremely competitive right now. On the other hand, agencies have always hired economists at a time where they could make more lucrative, higher pay by doing other things, but there is a cadre of people interested and committed into doing public service. So they need to get people who can understand some things a little bit better. So let me give you some examples of what I have in mind. So for example, I've already said in my opening remarks, we need to tie particular uses of data to particular business models in terms of how they're being used and what you need to do to make it actually effective in understanding how things work with diminishing marginal returns. The other reality is there's some basic distinctions in types of data which have largely flown under the radar. For example, one is the distinction between structured and unstructured data. And what we're discovering particularly with structured data is really requires very little scale, and the algorithms are very well established. The contributions of having fancy data scientists get much less. These are data collected to motivate a particular model, and they really much map into a traditional idea of a database. Unstructured data has two different qualities. One, it really requires a great deal more scale. And so understanding that, in fact, when you're in the unstructured data world where it's not actually motivated by a model, It plays an extremely important role. Second, in many other areas, even though you acquire more data, there are often many more alternative sources of supply. That because it's unstructured, having a particular control of one output or one regime actually does not necessarily mean other people can't get an access to it. But the other big difference is in unstructured data, there is a tremendous role for data science. And that in fact, better algorithms can create better, improved results even with less data. And there's a trade-off there in terms of how you invest in them. And so understanding just in terms of the type of data you're working with and how it's feeding your model can radically change how you view the importance of scale in the data you have. Now, the other big innovation that's going on that's sort of flying below the radar is, if you will, more targeted generative AI models, which can often be trained on lower amounts of data, but higher quality data, often for a particular domain. So this is in connection with the Law Review conference. You could see in their discussions about creating generative AI models that are specific to law. In which case you don't need mammoth amounts of just raw data taken off Wikipedia or Reddit. What you need is a very specific corpus, aimed at a particular dimension, and that in fact you see a different question there about access. It's not about scale anymore. It's it's a question of getting able to get the corpus to train, for example, a law-specific database. We all know about the advantage West Publishing has had in U.S. law because they are the official publishers for lots of different of reporters and state codes. But we now know in the modern world, most jurisdictions are committed to open access law. We have numerous finding tools that can provide us to access to large amounts of law. And we have a very different environment. So I would say that in the world we're living in, we're seeing different types of data requiring different scale, but the real innovation to me is this notion of a different type of more targeted generative AI model where you're actually looking at not so much the quantity of the data, but the quality of the data in terms of its fidelity, but also in terms of its scope, that can actually yield you tremendous benefits. To have enforcement officials just talk about the scale of data without understanding these dynamics risks having them target different frame inquiries in ways that I don't think would be actually productive and could actually interfere with the deployment of generative AI.
Yeah, thanks a lot. So, Robert, now I'll move on to you. So let's imagine for a second that we know precisely what we want to do. So let's imagine a foundation model based on legal data. You do argue, and I want to come back to what you mentioned already, that the fair use doctrine may apply differently when it comes to pre-training data to what you call the curated data, right, for the fine-tuning. Why is that? So could you explain, because I think this will be, we can imagine already the litigation around this question that will, probably be worth a couple billion US dollars. So can you explain again why you think that the fair use doctrine may apply differently to those two kind of data?
Absolutely. So just to make sure that we're all on the same page, what kind of distinction are we drawing in the first place? When we talk about pre-training data, what we mean is very large corpuses of unstructured text that were generally scraped from the web somewhere. In a legal context, that might be, a large repository of judicial opinions, or a bunch of briefs that have been, prepared for some completely different purpose, but then submitted, or contracts or something like that. Fine-tuning or curated data, or sometimes called supervised data, is something different. That is a type of structured data that was created for the purpose of training generative AI models. So what would that look like? That might be, in a legal context again, an argument that someone would like to make, and 3 different possible citations that support the argument with the correct citation labeled as like the correct answer, right? So like a kind of multiple choice style question. Or it might be something more subjective, like, which of the following arguments about the fair use doctrine is most convincing, or something like that. And generally, when we're talking about these kind of curated data sets, they were created by usually researchers. The vast majority of them are created by researchers at academic institutions for the purpose of pushing the boundaries of AI research, right? So they identify some gap in the data sets that are available. They say, we want to do better in reading comprehension or question answering, or, trying to respond to people's queries in a most effective manner. And so they create a data set like this. And so then turning to the fair use analysis, very briefly, there are kind of a few factors that you want to consider. One is whether the purpose of the use is the same between the first, like the primary use and the secondary use. In the pre-training data, the purpose is very different, right? There's like this strong distinction between the purpose of a Wikipedia article as something that informs somebody versus the purpose of a Wikipedia article as something that we use to get a more performant generative AI model. So that's kind of the strongest, I think, most obvious argument, even for like non-legal folks, that these fine-tuning curated data sets were created for one purpose and one purpose alone, and they're being used in that way. There's also some things you should consider related to markets, and I think we'll talk a little bit about kind of markets more generally later. But when I use somebody's Wikipedia article, or if I use somebody's poem to train my generative model, and really what that means is somebody's poem finds itself in this large corpus of pre-training data. It's not as though the alternative to that is that I would go to the person and buy the poem. I would simply not use that poem for pre-training. There isn't really a market for people creating works of art or writing or whatever for the purpose of creating pre-training data. By contrast, there is a fairly vibrant market, fairly lucrative market for fine-tuning data. And so we argue that there's a stronger market effect if I simply use a fine-tuning data set or a curated data set without remunerating the creator. I'm robbing them of economic opportunities in a way that's slightly different from pre-training. I will caveat, by the way, and then I'll end, that we have seen examples of pre-training kind of deals, most notably perhaps the Reddit arrangement, where it seems like they're able to extract quite a lot of value. But the distinction there is that it's a huge corpus and not an individual piece. And the kind of level of abstraction that we're focusing on is the individual, like atomic pieces of data or the individual data sets, as opposed to these very large corpuses. I hope that's helpful.
Thanks a lot. So let's imagine that someone is very skilled or a very amazing team, and they did manage to find the data, to analyze whether or not this is fair use, to use it for the purpose of training the model, the fine-tuning, and are finally ready to put a product on the market. And I'll now move to you, Orly. You did mention that around the globe, it seems that to the question, should users be able to know when they interact with something that is AI generated, policymakers are moving in a direction in which the answer is a resolute yes. And you say, well, it's more complicated than that. But for now, which regulations do you have in mind, and which kind of solution have policymakers invented to indeed, put us in a position where we can always know when we interact with AI?
Right. So the EU Act, Article 52, says, it's kind of titled Transparency Obligations. It says that providers shall ensure that AI systems intended to interact with humans are designed and developed, that people are informed they are interacting with an AI system. But that kind of right has been appearing in other places. The GDPR already has, the transparency rights, Article 12 and on, that have been interpreted to similarly a right to know and to opt out of algorithmic decision-making. California has passed actually already in 2019 the bot disclosure law that requires what it says about to disclose that that you're a bot when you're chatting with a consumer, and then I mentioned that the Biden executive order contemplates that we do more research and work more. The the authorities, federal government works more with private entities to develop labeling, watermarking technologies, as well as just thinking about transparency and alternatives to kind of AI, both generated and just AI decision making, and kind of thinking about when we need a human in the loop. So we have all that kind of range, and there's other places like Ontario has the same right in Canada. But already just within my answer, I show, you know, I just kind of, I think, exposed that these are not, you know, kind of wholesale, would not really lend themselves to any kind of, or to every kind of question that we have and any kind of automation that we're thinking about.
Let me do a quick follow-up. So what's the consequence of that? What do you think will happen? People won't care anymore about whether it's AI or not, or they will be confused?
Well, yeah, so right. So the big question is, right, what are the consequences, right? So, and that's what I want us to ask. And so I think that if we have as a default a rule that, you know, people have a right to know that they're interacting with the bot, or that the decision making or a decision about, like, you know, in their hiring, in their application for a job, or in, you know, credit lending applications, or, you know, some interaction in a grievance procedure with a public or a private entity, that they have a right to be notified that there was some AI behind it. I think, again, that we create these defaults suggesting that actually you should care about it. So the reverse of what you said, like that there's something not natural and also scary, and I would link it to how, in a lot of ways, we've been kind of overemphasizing some of the fears and the risks, and not thinking about the positive, you know, benefits and the improvements that come on all these different, you know, public goods that we want to get, like equality and safety and accuracy and access, that come from a shift from a human decision maker to an artificial process. So again, it sometimes it might have value, but as a default of, you know, you have to kind of, and if it's, I think, to answer your question differently, if we do not require that everything will be designed to prompt, you know, like at the minute of, you know, at the moment of interaction, that there's something artificial in the interaction, then I actually think that we users will be forced to be more sophisticated and savvy. You know, we talked throughout the day about, for example, what do you do with misinformation and elections and you know, in different political campaigns. And I think the morning started with like a Biden video, right, talking about something, and the speaker suggested that, well, maybe we as consumers actually can learn to, and maybe already that's true with the new generation of users, that they kind of assume that, you know, a lot of things can be just like when you're watching a Hollywood movie. It's not necessarily, you know, true, and they have to be more proactive and differentiating. I think there is some cost in kind of this, let's always inform. I would give, just to close, the analogy of how we kind of thought we solved a lot of things by, in privacy, by mandatory disclosures, which, you know, if you look at the research, it really didn't solve that. You know, it doesn't always line up with consumer preference, and it's certainly created, you know, a lot of times its own problems.
You know, to talk about complexity again on this panel, we do rely, of course, on the idea of the average user, average consumer. We hear that, well, maybe people will become more sophisticated. At the same time, we have a decision from the European Commission published earlier this month in the Apple Spotify case, in which the Commission says that if you cannot subscribe to Spotify Premium within the app, people won't actually, because they do not know how to do it, go on Spotify website to take a subscription, right? So the commission seems to assume that people are not at all tech savvy. Well, maybe we can use a bit of complexity and agent-based modeling to have some more granularity in how we perceive consumers. But for now, coming back to solutions, and I'll go back to you, Beatrice. So, and we discussed that to some degree it seems to be a common theme that I was not expecting would emerge in today's conversation, which is the geopolitical risk, a question that Paul asked regarding, Taiwan and China. So let's assume that, and to some degree I could see how this could unfold. Some countries would say, well, if you are based here, you cannot use all the data available on the web for the purpose of training your model. And let's imagine that there is another country that we may call randomly the Emirates that would say, well, or Japan, if you come to my territory, you can use any data. And I will not enforce, IP, any laws against. This will create probably a loophole in attracting those companies to that country. So from a data governance perspective, is that a good thing? Should we cherish this kind of competition between countries?
More than a good thing, I think it's very likely. And I think there might be something interesting for sure happening of having different countries and regions adopt different models so that we can see to a certain extent what happens. So I think the EU played and plays an important geopolitical role with the GDPR, and then California adopted something similar right after, but it's also a process of continuous learning. And so I think there is something to having different places choose different regimes, kind of in a decentralized model, the way US states operate, at least in theory. I think the cost of that, and of your example, and of many other like data sovereignty initiatives, is that it does come at a cost of a global internet and digital economy. And this is, I mean, AI governance might be ultimately be a global challenge, even if it's a great opportunity, that requires eventually some global coordination. So I could see how in that example, the EU decides that there's some traffic from Japan or the Emirates or whatever, that's just not gonna be managed by ISPs in the European Union, because that might be against European citizens' privacy harms, right? Like the way some websites don't operate in Europe because they're not GDPR compliant, like that can start happening the other way. But it is a trend that we are seeing, and that has its costs as well.
Hashtag TikTok, hashtag United States, right? So Christopher, I'll go back to you now. So in any case, each country has to take a position. And there is one clear trade-off that we discussed between privacy on the one hand and competition on the other, if only for the fact that if you don't have access to very specific data, as a small company, it's harder for you to access a niche market, which you need as a startup. So what do you make of that? And do you think that, let's say in the US, there is already a market dynamic that is being impacted by the privacy regulations that you have, or at least the discussions of federal regulations at that level?
Well, there's no question that there is a dynamic going on here. We see an interesting tension that's very well identified in the literature. For competition law purposes, we see people asking for data portability and more fluidity in it. And we've long recognized that even though that serves competition law goals, it actually can hurt data protection and privacy goals and run afoul of data protection law. So the clearest example of this is Italy last year put a moratorium for 1 month on ChatGPT, and then in late January, they gave a notice of apparent liability asking OpenAI to show cause why it shouldn't move forward, because the way that GDPR is structured does put significant impediments on the use of data, particularly the way Gen AI uses it. So what matters for the GDPR is whether the information is personal information. A lot of the industry thinks about it whether the information is publicly available and assumes that it's usable just because it's publicly available. Under existing regimes, that's just not true. and that in fact, if you have personal information, you need to have a legal basis, and you're subject to a wide number of obligations, access, rectification, erasure, right to object, and so on and so forth. And what we've discovered is that, in fact, that is having a direct impact on companies' ability to compete. There's a growing evidence that it's reduced venture capital investment. It's had a negative impact on SMEs who have trouble developing the compliance regimes to do this, to build this. And what you see is a de facto competition emerging between different regimes based on the restrictions they put on the use of data that people strongly suspect will cause distortions in the market and will cause innovation to go elsewhere. The most recent innovation of this is not strictly speaking data protection regulation, but the EU AI Act has decided to create a new category, which is general purpose AI that creates systemic risk. The systemic risk is really tied to the number of calculations used to train the data. A lot of people have been extremely critical of this development. First, it violates the principles of technological neutrality that was originally embodied in the EU AI Act. It deviates from the risk-based approach, which looked and returns to focusing on inputs instead of outputs in the risk. And to me, there's a consistent problem with making technical definitions, which is it's destined for obsolescence one way or the other. It's just not likely to last very long. But the other problem is it was by reports very closely tailored to not to catch the emerging AI companies from Europe like Mistral and Aleph Alpha. And if that's the case, and we saw this, for example, with some of the proposed antitrust regulation intended to limit digital marketplaces, which were sponsored in the US by senators from Minnesota and Arkansas who went to great pains to make sure it didn't pick up Walmart and Target, even though they're the most significant competitors as bricks and mortar companies to the online competitors. And I think that anytime you have a process like this, it's vulnerable to this sort of bespoke gerrymandering to try to make sure it favors certain interests and not others in ways that I think have potentially a way to distort markets and really harm innovation at a time when you need companies to have a lot of freedom to experiment in different ways if we're going to see the full realization of the full value of generative AI.
All right, so here's what I'm going to do. I'm going to go to you, Robert, because the question is related, and then I go back to you, Christopher, because then I know you have to go. So Robert, the question is this: what are, again, looking at the consequences, what are the consequences of not addressing those issues that you may call, issues creating legal uncertainty because you have trade-offs here between privacy and competition, and policymakers sometimes may have a tendency not to say that there are no trade-offs, right? That every regulation moves in the same direction, which of course is not always true. So what are the consequences when it comes to or surrounding AI training data, if indeed we refuse to say that there are trade-offs and that we make a political choice, we favor privacy or competition, for example?
So I'll preface by saying that I really don't think that in the curated training data case, the issues relate to privacy, right? For the most part, there's very little data in there that's like, that would qualify as personal data under the GDPR or anything like this. So it's not really privacy that we're worried about. What we're worried about are the other types of AI harms, right? More related to bias and like blind spots and, hallucination, things like that. And the kind of core argument is that, first of all, if you want to really understand the risks and the limitations of large generative, LLMs and AI models, a really good place to start, and perhaps the only real place to start, is the training data. And having insight into what went into the model tells you a huge amount about potential issues. I'll give you like a quick example. We found that there's, everybody already knows that there's kind of Western centricity when it comes to the languages that the AI models are trained on. We found that there's a tremendous amount of Western centricity, even more so in the dataset creators. And so you have actually non-English, non-Western language datasets created by folks who are not in the relevant countries, and this makes us worried about whether those data sets actually capture cultural contexts and nuance and things like that. So just as an example, this is the kind of analysis you'd want to do. Now, we live in a world right now where, although fairly few players are really capable of training large language models, the ecosystem of training data is highly fragmented, very global, very diverse, and very, very open. And our worry is that as the data sets that are being created by researchers are used without respecting the license agreements, we will start seeing less and less openness. We're already seeing this a little bit in that we're seeing licenses becoming stricter. So there was a big shift in 2023 from generally most licenses associated with this data being open for all purposes. Now the licenses generally restrict themselves to only non-commercial purposes, and for commercial purposes, they kind of realize that there's a value. That's still okay, but what we want to avoid is kind of a closed source world where these data sets are not kind of openly published, where there isn't kind of discourse and the ability to trace this provenance. And so from a competition perspective, where kind of competition comes in is to say, look, like, if we do start approaching this closed source world, then it will take way, way, way more in terms of resources in order to be able to get access to these data sets. And so that creates a further imbalance between the large providers of large language models and researchers, smaller nonprofits, smaller companies that are trying to look at LLMs in specific application domains. Right now, all of this data is available. And so we're just trying to make sure that the incentives are such that the folks who are creating the data continue to publish it openly, because it seems like it has many kind of useful externalities if we do it that way.
And indeed, it might be that because of legal uncertainty, one way to manage it will be to close access to your model, so you create your own private regulation around it. I go to you now, Christopher. Looking again at this issue of trade-offs, if you were the head of the DOJ antitrust division, how would you address those trade-offs? I mean, I guess this is a biased question because if you work for the antitrust division, you will favor competition. But is there like a magic formula for policymakers? What's the proper way of discussing and dealing with those issues?
Well, first and foremost, I would take a longer-term perspective and avoid a certain amount of the short-run hysteria you see somewhat. I think there's some knee-jerk reactions that don't take a long-term perspective on the issues. So to give one example, anytime you get a technological change, you can see new actors playing key roles. One of which is attracting an enormous amount of attention right now is the chip maker NVIDIA. They had done these graphics processing units, which used to be part of PCs at a time where the PC industry was largely in a very steep decline, and in fact was going down out the window. And the advantage of GPUs is they do parallel processing, and apparently the CPUs are doing linear processing, and apparently this is what AI really likes. It makes it much more effective. So apparently NVIDIA has 80% market share right now. And it'd be very easy to think, oh my goodness, what a horrible antitrust problem. We'll think about this. Setting aside the fact that it's just a classic luck issue, and it's not like they designed this particular chip with this in mind. And the market just moved towards them, and that's not traditionally something that's the sort of antitrust intervention. But much more importantly to me, which is if you think about it, we're at the beginning of the AI revolution. The idea that NVIDIA is likely to have a market share that large in future years is very, very uncertain. And what you'd likely to see is companies like AMD and other chip manufacturers are almost certainly retooling what they're doing to create parallel processing units. And that by looking at the fact in the early days, someone's going to have the early lead. It's just going to happen. They're going to look extremely dominant, but their early dominance of the first actor is not necessarily reflective at all of what the likely problem is going to be. And I'm worried that looking at immediate problems might be to make people react in a too knee-jerk manner. The other thing about in terms of the trade-offs is I want to make sure that I would be sure that in fact that we think about the trade-offs in a way that really maximize social welfare in the traditional competition law sense. Now, to give you an example, in the data discourse, it's often done in terms of rights. And a proper rights discourse would include proportionality, which would yield a balanced analysis, but they're often asserted now as trumps, which I think is a problem. In addition, the proportionality is often phrased in terms of other rights to other individuals versus society as a whole. And what we see in many cases is there is actually a societal consideration or a social welfare consideration which often isn't framed up very well. To take one example that moves outside a little bit of Gen AI, but more about the availability of data, There's a really nice empirical study done by Leon Wogman, who was one of the primary policy people for the Federal Trade Commission when he was on leave from his university. And he tracked the shift in a number of San Francisco Bay Area municipalities of shifting a consent for private information on financial information from opt-out to opt-in. And the bottom line was the lack of availability of financial data effectively caused mortgage prices to increase, not just for the people who made optional decisions, but for the market as a whole. Why? With the lower availability of the data needed to sort out risks, separate good risks from bad risks, they simply had to charge a risk premium on all individuals. And this is going to show up in markets and show up people who didn't get mortgages or weren't able to buy houses as a result in ways that's often not taken into account here, but is a critical factor, I think, in terms of understanding the benefits of how we can realize the benefits for society as a whole.
So you did mention, how we react to new technologies. There is a great book by ALTI Morrison. He was a professor of the history of technology at the MIT, and he published this book in '61, showing that people in positions of power, because they benefit from existing technologies, they tend to first ignore new technologies, then to say, stage 2, this is inefficient, it will never scale, and if it does, stage 3, the name calling, right? So I'll leave it up to you to see where we are when it comes to Gen AI. Christopher, I just asked a bonus question. I will ask for a very short answer, and so then you can go anytime you need to go. You argue that the Google case in the US is a good case from which we can learn, a couple insights as to how to deal with Gen AI. On the contrary, which case do you wish policymakers and regulators will ignore because it is an absolute disaster and should not inform how we deal with generative AI?
What do I wish they'd ignore? So the case that, the one area I think that we always have to ask the question as opposed to what. And we see certain disasters, it's not a Gen AI case, but it's an AI case. I'm thinking about Tesla, the Tesla crashes. And there's a tendency to hold AI to a perfection standard when it is in fact predictive analytics. And that in fact, it has to be about acceptable risk. And it's very easy to paint up some nightmarish scenario where you clearly had a bad outcome. And that is almost inevitable because even at 5 nines reliability, it's going to show up at scale. At 1 in 100,000 or 1 in 1 million, pick your number of nines. There is no perfect outcome. And so by de facto fixating on extremely bad catastrophic events, without taking into account that the alternative regime of non-AI base also has its share of extremely bad events, can create a myopia that defectively holds AI to a perfection standard that it cannot meet, and that if we do so, it would deny us the benefits of the new technology.
All right, thank you so much. And of course, no problem at all. That's the beauty of technology. We are all movable. Oli, I'll go back to you, and then I'll ask if you have questions on the floor. So you do, and I love this argument. I've used it already so many times since you wrote it for the NLR. You do argue that imposing watermarking on anything that is AI generated could discourage some artists from exploring, the possibilities and indeed what we may call the hallucination or non-deterministic ways by which AI evolves. And so against this background, you say, well, maybe a potential solution is to impose watermarking or other solutions, but to target that to very specific sectors such as news or, during political campaigns and so on and so forth. Now, my question is whether or not there is a risk that if you do not impose watermarking, it could also, legitimize something that is indeed fake news and AI generated. So in a sense, how do we approach, and again, we come back to this idea of balancing human rights and the right to know versus innovation and creativity. How do we do that, if possible?
Well, those are hard questions. How did we do that? And that's where, we've been talking about how we need the science to work together with the policy. And I know that there's a very lively and kind of active question within the the designers themselves, the CS, field of how effective watermarking can actually be. So there's a technical question to begin with. But there's also the more kind of normative and behavioral question that you're alluding to. And all of them have to be considered together with kind of a purposive view of, why are we requiring some things. I will say, just to begin with, that I've been kind of my starting point in the presentation was that there's even like this clear line between what is AI generated and what is human generated. And I want to even, complicate that. In previous industrial, post-industrial technological revolutions, we've also thought that, these interactions, human-machine interactions, are artificial at the point that we need to still have a warm body in some way of the train driver or things like that. And what you were saying about the cost of watermarking or demanding watermarks and creating imposing liabilities and not on just aesthetics and artistic play can be very real. So artists, I think there's the whole spectrum. Like, a lot of artists are actually very much embracing Midjourney and DALL-E and all the video things, and they feel that their contributions are very real, even though it's something that would be deemed generative AI. So a lot of the talk up to now has been about the data that goes into the inputs, but we didn't talk about who owns the outputs and subsequent and that. But I was alluding to this, and I didn't really kind of unpack this, but IP also has this history of we become so connected to the idea that something is property that we forget that it's about the igniting fire, and incentivizing genius, and it's about creating progress in arts and sciences rather than impeding it, and so it's really an empirical question of how are we going? So again, if you said this, if the watermarking is kind of a protective thing for copyright, that's a very different question and goal than if it's to help prevent, for a particular purpose, like during elections, election, abuse and misinformation.
All right, so I'm going to take questions from the floor. Is there any question? Yes. Oh, a couple. Yeah, go ahead.
Thank you very much. Very enlightening. Orly, I think it was something like a comment I made in one of the versions we saw earlier, and I was also, like Thibault, very inspired also by your work. So thanks very much. The question is, you might remember that I call this stuff consumer-facing AI, and I think when we discuss that stuff, it could be something like a Russian doll thing. What are we looking at? Where do we have trust? If we watermark something that is artificially, synthetically generated and is the output, could be something else that is a human, completely informed in his words or her words and actions by an AI, but still has the warmth, has the ability to connect to a human. So how is this made transparent? And how do we deal with the fact that specific forms of AI can be injected at every single level of a value chain?
Right. No, that's a great question, and that's why it's so hard in advance. I think I very much subscribe to this idea of don't do things that are too precautionary when this is so unfolding. And we know that what you're describing, that emotional recognition and social robots are really right now underway. We're still so uncomfortable with really recognizing their value. They're different. They're cultural different. In my book, In the Equality Machine, I really kind of travel the world to see why certain cultures, certain regions are more comfortable with that kind of what you describe as the feeling that there's also warmness and different things, not just accuracy when you're interacting with a chatbot, for example. And so again, I think I would just emphasize the empirics of this, that first of all, we're in a transition time, so people get more comfortable and more sophisticated on assessing, their interactions with new technology over time. And B, that we need, it really depends on who is that user interfacing, So for example, I look at studies with physicians where they are presented with different recommendations. And you can do this in experimental ways, and I really like these kind of experimental studies that can manipulate just what's presented to the user, even though, let's say, both of the presentations, both of the recommendations are really AI generated, but a physician is told that one is produced by an algorithm and the other by a fellow physician. And there are very clear studies that show that, again, it will be context-based. It doesn't mean that it's like you can do an experiment in one shot, it will carry across context. But there are contexts where a physician is more likely to override the bot versus a fellow physician. And that's very harmful. That there's a huge cost in that to, just to health and to patient care. So it really, we have to, constantly, what I would say is that we shouldn't only think about trustworthy AI and auditing the AI itself, but we should think about trustworthy human-machine interaction and auditing and assessing that interaction.
On your exchange. So I wonder what will happen in the long term. So I can imagine a time where people would be happy to know that their surgeon, their driver, their pilot is AI or AI aided, because it would be so clear that AI outperforms humans by orders of magnitude. So this would be an advantage, or perhaps something we would like to incentivize.
Absolutely. So that's why I was saying, transitional. I think that it's about rationality and, making sure that we're not creating noise and misinformation by having these prompts. So actually, my husband is, a former fighter pilot, and now he flies, little commercial planes. And I think I mentioned that he has a different last name as me, so I mentioned that I have a study with him, experimental, on Amir, about how consumers, passengers would understand commercial aviation if the pilot would say in the highest risk. I mean, ironically, the EUL has those rankings, right? Like the highest risk, so then, maybe the default should be a human in the loop. But with global aviation, we as a global community have decided decades ago that actually at the highest risk, conditions, a plane has to auto land, and there's no human. It's not only that it's like you can, but you must take the human out of the loop, the pilot. But we still, I think, are not there, even though it's been decades, are not there of the pilot telling the passenger, just so you know, I have no control over landing right now. And so I've actually talked, Christopher ended by talking about Tesla, and I've talked about this quite a bit in my state in California. There was a recent bill that tried to ban truck drivers, and all the evidence shows that, or sorry, not truck drivers, autonomous truck drivers, so autonomous AI drivers, just in the trucker industry. And there's so much irrationality. So yeah, I hope to get to that place, but it takes a lot. I think we're kind of biased toward, it's a bigger behavioral bias, that it's kind of the holier than thou, self-trust versus skepticism about others, the want of control, the status quo bias. There's lots of behavioral biases that all operate toward, kind of irrationalities here.
Volker, make it very short. Yes. I only have the following question. What I'm seeing was much about IP law, what the discussion also was about. That there is a tendency I see from my research that there is of creating more IP-like protection of data, and in different ways. So I see this in the Data Act, which is very specific about IoT data, but I would be interested also from you, because you go more in copyright law, what you see in this direction, because we have seen very important that still many data sets are available, but I think this might also be more enclosures of that through IP or through other methods, and I'm very worried about this for innovation.
Do you want to go first, Robert?
Yeah, sure. I can take a stab at it. I think one of the challenges with applying kind of the existing IP frameworks is trying to figure out what we're actually protecting. Because when we have these generative models that are using intellectual property in a way that's really, it's never been used before at like in that kind of scale, it's like difficult to figure out to what degree we are learning kind of protectable elements or just, basic syntax and like facts about language which are unprotectable. It gets really challenging when, on the one hand, LLM producers tell us that they're just learning, basic syntax, and on the other hand, we can then recreate, all of Harry Potter or half of the New York Times and things like that. So some of this is like technical safeguards, and some of it is that the IP framework is just not necessarily fit for purpose. That said, it seems like the best we've got right now, at least in the US. So it's a fine place to start. Curious what the others think.
I see something similar. There's a lot of licensing happening of large databases, but also just increasingly contractual clauses and MOUs that different actors use to share data privately, so try to keep it enclosed. And that's a function of the value of data. So the Data Act does that a little bit regulatorily, but I think in the industry, you have a lot of data sharing that happens only at the inside level so that people keep control. But I want to echo something that you mentioned in the passing, which is that I think I'm actually more of a privacy person, I guess, than a copyright person. But I think increasingly we're using these frameworks that we have to solve problems that are more systemic and like we're stretching these bodies of law. Like I'm not sure AI bias is a data protection problem, but it seems to be what we have. But I think there's something that we lose there. We lose the bigger picture and might be creating harms elsewhere.
All right, let me move on to a quick bonus question for you all. And I'll start with you, Robert, and I'll make it easy for you. For you, though, this is going to be very hard. So, Robert, I wanted to ask, what the AI developers can do in terms of mitigating the risk. So here's the bonus question, and maybe you could use this one as a way to answer it. Please explain what is the main difference in terms of mindsets between people you've worked with at Harvard Law and people at the MIT.
It's an interesting question. These bonus questions are good. This is the easy one, you said?
It's the easy one.
But it's the dangerous one.
It is a dangerous one. I mean, I think, the easy answer to this is that there's a very different kind of attitude toward like what the law is. Whereas when we work with folks at MIT and kind of computer scientists more general, it is viewed as I think, somewhat difficult to understand obstacle that needs to be quantified and surmounted. And so we see this, when people say, well, like we'll just, find some safeguards so that, two images aren't too similar to each other, and then we won't have copyright infringement. And then it's like, well, but it's not so simple, and there's like a subjective element. And that kind of second part, right? Like that more nuanced approach, like getting into the law and like pulling it apart a little bit, that you get with lawyers, but then they're a little bit intimidated by the technology. And so I'm very proud of the fact that we've been able to bridge the gap. I mentioned at the beginning, we started this data provenance initiative to study fine-tuning data sets. Now we're expanding to pre-training data sets. We have 45 collaborators, computer scientists and lawyers and others. And I think that really interesting things can come out of that. I don't know if that answers your question fully.
No, that's a great answer, and it's very impressive work. So thank you so much for being on this panel. One for you. So you wrote a book called The Equality Machine. What would be the main argument of a book you could write that you would title The Liberty Machine?
Like you knew, I will ask the question. I did not know, but I'll take the liberty of answering it. So I was just presented at a different conference as like the thread that of all my research is about liberty, and so I actually think that, you know, just like equality, liberty is a really multifaceted, complicated, internal tensions kind of concept, but we really want to have human thriving and human welfare, and we just don't want that to be lost with the great benefits that AI brings us. So it would be very similar, and maybe I'll write it. Maybe that's my next book project. But I think that what is really my motivating kind of engine and working in the field is that I want to have a balanced, informed conversation that propels us forward to recognize, you know, that we can really correct so much of human misery, our world's wicked problems of poverty and climate and no access, you know, limited access and disparities and inequities, to free ourselves and to use technology for that. So technology is a tool, AI is a tool, and that's, you know, how we continue to think about it. And if we're just afraid, or if we're just kind of, you know, overly optimistic and not balanced, then we're losing that.
All right, thanks so much. What I hear is that this book could have been called The Liberty Machine in a sense.
It almost could have, yeah.
Could have.
I need to write a new book.
All right, final question to you, Beatrice, of course. What do you wish that EU policymakers would learn from Colombians? Yeah.
Colombian.
That's why I'm asking. Or Brazilian if you want, but...
Salsa dancing, I guess. No. Seriously, flexibility. Because I think... so Colombia is an upper middle income country these days, but with a very informal economy also. So I think there's governance challenges that come to it that require kind of adapting a lot to messiness, and the world isn't necessarily how the law predicts it to be. And I think we can learn a lot of European policymakers, but I think a skill that I think people who do policy in the global south in general have is kind of quick adaptation to reality on the ground, because it surprises you very often.
All right, well, you all did very well. It looks like I communicated those questions to you in advance. I promise you this is not the case. Thank you so much for such a great panel. We're going to have some coffee and sweets, and we'll resume here in about 20 minutes for the very last panel of the day. So again, thank you.